The Law Factor with advocate Clarence Arenas Gandawa.
Licensing is not a privilege granted at whim. It is a legal entitlement governed by statute, procedure, and accountability. Across sectors, health, education, broadcasting, trade, regulators wield immense power. They issue licenses, they suspend them, they revoke them, but when that power is exercised without cause, without hearing, without law, the institution is not at fault. Over to you, Advocate.
Thank you, Stella. Greetings of the day. A regulator is not a monarchy. Its authority is not absolute. It is statutory. Licensing authorities are bound by enabling legislation. They must act within the scope of their mandate, follow prescribed procedures, uphold the principle of administrative justice. Whether issuing a trade license in Ezulwini, a broadcasting permit in Nairobi, a professional certification in Pretoria, regulators must ensure transparency, consistency, legal compliance. Failure to publish criteria, failure to notify applicants, failure to justify decisions, these are not administrative lapses. They are statutory violations. Procedural rights of applicants and license holders. A license is not just a document, it is a legal right. And every right demands due process. Applicants have the right to fair consideration. License holders have the right to notice, hearing, reasoned decisions before any adverse action is taken. Suspension without citation, revocation without hearing, reversal without explanation, these are violations of procedural justice. The principle of audi alteram partem, which means let the other side be heard, is not optional. It is constitutional. It is binding. It is the foundation of lawful regulation. Legal remedies, administrative review, declaratory relief, and judicial oversight. When regulators offend the law, institutions must respond, not with protest, but with precision. Administrative review allows institutions to challenge decisions within the regulatory framework. Declaratory relief affirms rights and clarifies obligations. Judicial oversight, through writs of mandamus, certiorari, prohibition, compels regulators to act lawfully. Courts do not tolerate arbitrary action. They demand justification. They enforce fairness. They restore rights. Institutions must not hesitate. When the regulator errs, the remedy is not silence. It is litigation. Case examples: suspension without citation, reversal without hearing. In Goss versus Lopez, the U.S. Supreme Court held that suspension without a hearing violates due process, even for students. The principle applies universally. No person or institution may be deprived of a right without fair procedure. In South Africa, the Labour Relations Act affirms that precautionary suspension must be justified, time-bound, procedurally fair. Failure to cite reasons or offer a hearing renders the action unlawful. In Long versus South African Breweries, the Constitutional Court emphasized that even internal disciplinary suspensions require procedural safeguards. These cases are not exceptions. They are precedent. They affirm that regulators are not above the law. they are subject to it. The law moves forward, you must move with it. See you next Thursday.
Springfield Law Clinic, justice defined, rights protected. We are here to serve.